like to welcome Andy McCarthy from Weintraub, Tobin. He's going to highlight, if you're a startup, what do you need to do to stay investment ready and get funding so that you can go after hopefully stimulus money or other grants from the government or private equity.
Hi guys, good morning. Thank you, Brian. Thanks, Thomas. That was an interesting bit of material that Brian presented about where we were and what's happened in the meantime and what's likely to happen with the investment environment and also the tax rates and the structure and maybe closing some loopholes for corporations to move their tax revenues offshore, and especially the stimulus money that's pouring in to the economy. I think, just like Brian said, it's going to inevitably lead to capital that's going to be available to be deployed into companies of all sizes at all stages of development, including startup companies, and particularly in the clean tech space with just the emerging interest in these companies, as well as the support these companies are probably going to get from the government and from government spending and tax incentives as well. So today I'm going to talk about what companies need to do to be investment ready. And I'm sort of going to work backwards from talking about the types of investors out there and the types of investments. And then I'll end up talking more about what the companies should be thinking about, what the founders, the managers should be keeping in mind just to keep things tidy, so to speak, and to keep the company and the management in a position, and the owners in a position to talk to investors if they want to raise capital. So to break it down into two categories here, there are investors and there's types of investments. And there's also, you can look at it in the stages of development of the company and the stages of fundraising. So there's what you might call a seed rounds, friends and family rounds, which is just getting the company off the ground, helping the founders to maybe quit their day jobs. And then it moves to outside investors of usually increasing dollar amounts. Talking about friends and family, so many times that's just the founders themselves putting in money, their family and friends, their personal networks, and also there's the whole universe of angel investors out there, wealthy individuals who maybe full-time or just as a hobby invest in companies. And often these angel investors, as they're called, have networks and their own contacts. And if you can develop, as a founder, if you develop a relationship with an angel investor, sometimes that can lead to contacts with their colleagues, their friends, their network, and sometimes they even have small funds of themselves. And beyond that, not on this slide, but there are firms such as CVF and funds and venture capital funds. But I think that's a later stage in the fundraising process than what I'm mostly focusing on here. In terms of the dollar amount, now there are these rough labels. I wouldn't put too much stock in these labels, such as seed round, Series A, Series B. But if you're talking about a seed round, I think what most people are probably talking about is $50,000 to $2 million, usually less than $3 million. And if you're talking about more than $1 million, often the type of investment is an equity investment. Whereas before that, a lot of time you have convertible notes or simple agreements for future equity safes, which I'll talk about in the next slide. In terms of the number of investors, well, if you're talking about $10,000 to $50,000 each, you could be looking at anywhere from 1 to 10 investors to get to what the company wants to raise. And when you're talking about 10 or more investors, sometimes wrangling all those folks can be difficult. So many times these rounds are set up with rolling closings. So all the money doesn't change hands, and all the issuance of whatever instrument or securities the company is selling doesn't happen on one day. It can happen, for instance, over the course of a month. And then once the company reaches whatever target it wants or thinks it's going to raise, that's the round. And the closings can happen on any number of days, and the documents will be set up that way. So in terms of the types of investments, you've got, these are just some examples of pretty much the most common ones you'll see. The top two, convertible notes, simple agreements for future equity. These are instruments where the company gives them to the investor gives the company money. And this document, this instrument, gives the investor the right to receive shares like equity of some kind of shares of stock upon a triggering event, a conversion event. For instance, and this is what investors are most often looking for, a next big equity financing. And so, for instance, if a big venture capital fund comes in, invests an amount, many times that's specified in these convertible instruments, like $1 million or $2 million, or often $5 to $10 million, that will trigger the conversion of the SAFE or the convertible note into equity. And the conversion price is key. That tells you how many shares of stock the convertible instrument holder will get in exchange for what they initially spent to get the convertible instrument. So, and then you've got convertible preferred stock. That's the most standard type of equity security that's in a round where usually a big investor comes in. There's an idea of how much the company is worth, and that enterprise value is implied by the price per share that the investor is paying for their shares. And that also relates to how much, like basically what percentage of the company that big investor wants to own after they put in their money, the post-money valuation. So all those pieces are tied together: the price per share, the implied value of the whole company, that's a result of that price per share, and the percentage of the company that the preferred stock investor wants to own after the round. So here's kind of the meat of my content here. And these are just some things that a founder or anyone who is thinking about, who runs a company, who started it, and is thinking about taking money from third-party unrelated investors, these are things you might want to think about. And it starts with the type of legal entity. If you're a founder, you may not have yet formed an entity, and that's fine. Then you're, in that case, you're a sole proprietor. But often as things progress and you're thinking about entering into more contracts, maybe signing a lease for real property, you're going to want to have a legal entity. And the biggest reason for doing that is to limit your liability, to have that entity on the hook instead of you, in case some creditors come after your business, someone slips and falls. Anyone who might have a claim against your business, you want them to have a claim against your business, the entity, and not you. And in terms of the type of entity, so there's, I would split things in between corporations, C corporations, or pass-through entities. And in the world of pass-through entities, the idea is that all the income, the loss, everything that the business makes gets passed up to the owners. I'll call them partners, but it can be a partnership, but it can also be an LLC. And S corps are also another type of pass-through entity, which is basically a corporation that elects to be treated as an S corporation for federal income tax purposes. And so there's still C corporations for many purposes, but for purposes of federal income tax, the items of gain, loss, income pass through to the owners. Now, so if you haven't started an entity yet and you're just looking for the easiest way to form an entity, an LLC is probably a good bet. They're very flexible, they're relatively low cost and low maintenance compared to all the formalities that you might have to follow if you had formed a corporation, for instance. They're flexible in the sense that you can decide how to share losses and profits if there's more than one of you. If you're the only owner, then it's a single member LLC. And if you're an owner of an LLC, either by yourself or with other owners / members is what they're called, you can convert into a corporation relatively easily. It's a little more costly, a little more painful to go from corporation into LLC many times if you have built-in gain. Basically, it's once you have a corporation and that corporation starts making money and it builds up earnings and profits, it's very hard to extract those profits and those items, those pieces of property, those assets with built-in gain. It's hard to take it out of that corporation without the corporation itself being subject to tax, and then having the shareholders being subject to tax as well. So that's why a lot of times younger companies start as an LLC. Now, of course, many big companies also remain as LLCs as well. But in terms of getting down the road, if you're looking for a venture capital investment, many times those investors want to invest in a corporation. So that's one reason why you may need to convert into a corporation later. So the next thing you'll see is protecting brand names. Basically, this is just all about IP. Before you invest in the name of your company, logos, you want to do some trademark searches, make sure that's not already taken. And in terms of IP strategy, that's a kind of a broader umbrella of things you want to think about. And that includes having intellectual property assignment agreements, invention assignment agreements, confidentiality agreements with your employees, your service providers, as well as potential business partners or like co-venturers or other entities that you might want to do business with. Have things to protect your intellectual property, spell out that you continue to own what you own, and to give you rights in the event that you find out that someone is misusing intellectual property that's yours. Labor and employment laws. So the big one there is classification of independent contractors versus employees. Independent contractors traditionally are people who run their own business, control what they do, how they do it. You hire them for one job. You don't, in California, this has been the subject of a lot of development and case law recently. So it's much harder to classify someone as an independent contractor now in California as a result of those laws. And another thing, another basically requirement that the company has to meet who's engaging an independent contractor to get services from them is that if the company wants to classify that person as an independent contractor, the company can't be in the business of providing the service that the independent contractor is providing to the company. So why does this matter? It's basically wage and hour laws and benefits. Independent contractors are entitled to minimum wage, time off, breaks, whereas exempt employees, more white collar employees, are not entitled to those same benefits. So you just want to make sure you are classifying people, service providers, in a way that they are classified under the law, regardless of any label that anyone puts on them, so that you're complying with the wage and hour laws and similar requirements there. Equity-based compensation. This is one area where you probably want the advice of an attorney or even an accountant that's experienced with these issues. And by equity-based compensation, I mean stock options, stock appreciation rights, restricted stock. It can be a great way to compensate and incentivize your officers of your company and to hire people like that without paying them money right now. But you have to do it. Everyone has to be aware of the tax implications of that because it has equity-based compensation brings up issues that are related to tax for both the service provider as well as the company. And if you, as the company, adopt an equity incentive plan, if you set aside, say, 20%, 10%, whatever of your total authorized stock to be issued to service providers under your equity incentive plan, potential investors will care about that because when that's issued, that's going to dilute their percentage of ownership. Couple more items here. If you have a website, you want to think about the privacy policy and the terms of use for the website. Those are two basic things that you probably should have if it's anything beyond just like a business card that's online. And especially if you're collecting information, data, personal information from people who visit your site, you're going to want terms of use and a privacy policy. And if you're collecting a lot of data, if that's what your business is built on, you probably want to think about a cyber insurance and of course, implementing measures that safeguard the data and handle it in a way that's consistent with how you're saying to the world that you handle that data. And lastly, documenting relationships with all sorts of people. Documenting the company's relationship with founders is important, especially when it comes to what the founders have contributed. For instance, intellectual property or money or equipment. You want to make sure if that was just a loan, it's reflected as loan. If you want to make sure, if you want that to be reflected as a contribution of the capital of the company in exchange for membership units or stock, you want to make sure that's reflected as well. And in terms of, this also ties when you're talking about service providers, if you're engaging an independent contractor, you want to make sure you're able to actually call them that and then use an independent contractor agreement, make sure they're assigning any intellectual property that they create to the company so that you own it. So you make sure that they can't come back later and say they own what they made for your company. And this is, that's basically the list. And to tie this all together, you can think about it as if you do all these things, expecting to take money from investors potentially one day, think of it as if you're about to sell your business. You want everything very clear. You want to make sure you can demonstrate that you've complied with laws and that all your relationships are properly documented. Lastly, securities laws. Under federal and state securities laws, whenever a party sells a security, these are regulated transactions by statute and by regulations. And basically, anytime you take money in exchange for the promise of profits being kicked out to whoever you took the money from, generated from your business, that's a security. And under federal law and state law, definitely federal law and most state laws, as long as there's not a public offering, and you're talking to just one or two people, you're probably fine. So that's the most basic summary I can give you there. But if you're out in the public trying to raise money from many people you don't know, you definitely want to talk to an attorney or someone who's familiar with raising money by issuing securities. And so, you know, all these instruments, these are securities. So, so that's my presentation.